Good morning, folks. This is our 10 o'clock matter, and this is MEI Condominium Association versus First Service Residential Florida. Each side has 15 minutes, and we'll let you folks proceed.
Good morning, Your Honors. Patrick Dervishi of the Sheer Law Group, representing the MEI Condominium Association. I would like to reserve 3 minutes for rebuttal, please.
Okay, when you see that clock get down to 3 minutes, you know you're into your rebuttal.
Will do. Thank you very much. Good morning again. I will just dive right in. I'm sure that the court has had the benefit of the briefs, and we rely on those cases and points to the extent that the court has any issues for clarification. I would like to take that. But I think what this appellate matter presents to you is a condominium association who tried to meet the low procedural threshold and got its courthouse doors shut. We went to the lower court three times FSR for Service Residential, the property management of the association, moved to dismiss. The court decided that it needed more specificity in the allegations of the complaint. So we went back, we beefed up the complaint. This is not a 1-2 page complaint. It's 10-15 pages of the complaint. We added allegations to make it clear as to the nature of the claims that the association was presenting against the FSR. The two main issues that present the court today is whether the lower court incorrectly determined that FSR was the agent of the individual board members. There was a board member litigation in Miami-Dade County that was filed 2-3 months prior to this litigation. The caption of that lawsuit is the association versus Leo Chuela, Daniel Schmid, and Jose Pereira. Those were individual board members. The association sued under the breach of fiduciary duty. Board members have fiduciary duties towards the homeowners. The association acts as the through the board members, through the board as the entity. And I think that is the analytical framework that is being confused and unfortunately and respectfully improperly by the lower court. When you designate a board, or when you say that the association, a condominium association that is a creature of the statutes and must comply with the Condominium Act, must comply with its declaration of condominium and other governing documents, it acts through the board as an entity. It doesn't act as through the directors, meaning that the decision comes from the board, doesn't come up from the individual board member. The individual board member has a vote just like every other unit owner has a vote. In this case,
your argument is that the property manager is not an agent of the board, or is it that the property manager is not an agent of the board members?
First Service, the property manager or the property management company is never under no circumstances an agent of the individual board members. What we are submitting, the legal argument. And
what do you mean by an agent of the individual board members? Are you trying to assert that because the board members were sued individually, that that somehow that determines the relationship between them and the property manager?
That is correct. And the reason for that is because in the board member litigation in Miami-Dade County, when the association sued the board members individually for breach of fiduciary duty, it entered into a settlement agreement. And pursuant to that settlement agreement, which is the only argument that the summary judgment was entered into by the lower court on the contract claim, said that you released all your claims. The association released all its claims, all its contractual claims against FSR, because in that litigation in Miami-Dade County, there was a settlement agreement which specifically said, we release each other, the parties, which is the association and the individual board members, release themselves and their agents. So the question becomes, which is the question that you posed, Judge Harper, is if in fact FSR is the agent of the individual board members, then the trial court is correct. However, there is not one document that has been presented in a case such as this, where we never had a chance to go to discovery at all. Is FSR the agent of the board? Let's go with the premise that you said. Is FSR the agent of the board? And that is the distinction, the analytical distinction that we need to be careful, because when you say the board, you mean the association. You don't mean the individual board members. That is the confusion that is being raised respectfully by.
Let me ask you a question, Consul. But weren't they sued in their official capacity as board members? In other words, they were sued because of an alleged breach of fiduciary duty, acting as board members, acting on behalf of the association.
And that is, Your Honor, if you look at the question, but then you have to add the specific nature of the breach of fiduciary duty claim. It is true that these actions that we claim they illegally or unlawfully made were made during their capacity as a board member, but just saying and stopping there, it's only half of the test. Breach of fiduciary duty against volunteer board members under the condominium law, you have to find not only that, but you have to understand that there is personal liability, meaning that the association, if under corporate law, you cannot sue the board, the directors. You have to go one step further, because these directors, regardless of when the actions were taken, they incurred personal liability. That is quote unquote personal liability, which means that regardless of their acts being taken in the position of a board member, they were, one, unlawfully taken, two, they were taken in order to get to the breach of fiduciary duty, you have to pierce the immunity. And piercing the immunity means that not only did you take these actions, but you did
it sounds like your argument is that how you filed the suit, who you filed it against, and what the allegations are determines the effect of the release. And if that's the argument and it's a general release, I'm having trouble making the leap from this complaint was their lawsuits filed all the time against individuals who then sign a general release that releases claims that they can make, their heirs can make, and any number of people can make based upon those same facts. So I'm trying to understand how you're making the connection between how the original lawsuit was filed and what the language of the release. Shouldn't we look at the language of the release itself to determine what in fact was released and who was released?
And that is a great point, because we have raised it in our brief, Judge Harper. The release is between, and the parties are identified, because the parties in that lawsuit is the association and the individual board members named individually. I don't say you are a board member. I say association versus Aleo Chuela, Daniel Schmid, and or Jose Pereira. So we say these parties, and that is a great point, because we have raised it in our brief where we say there is the contract, the property management contract is between FSR and the association. The release is between the association and the individual board members. So when you say we release the agents of the individual board members, you're releasing the agent of the personal, the individual. You're not releasing the agent of the entity, because then you come into in this illogical context, because the association cannot sue itself and the association cannot release agents of itself, because under that premise, it follows that any homeowner can enter and claim an agent relationship with any vendor of the association. And we know under the cases that we have cited in our brief unit owners cannot enforce the property management contract, unit owners don't have that right. The right stays with the association, which is the point that we have. And I'm
So,
rushing a little bit.
Who would be the agents then if you're correct that they were just individuals? What would be the need to add that to the release? You know, because individuals that walk around without that are not corporate entities, that are not associated with a board, don't really have agents other than their attorneys. I mean, what agents would have been released then if your interpretation is correct?
And that goes back to what Judge Harper raised. You cannot release rights that you don't have. So I'm sure that counsel for FSR is going to say, well, all they had to do is carve out an exception for FSR. But there is no need to begin with. And two, there is nothing to carve out because a board member does not have any rights to control by itself outside of the board, does not have any rights to direct FSR to do anything. And that is exactly the reason why you cannot carve anything. So you have to go by the language, Judge Harper, the language of the release, and say, okay, who do you have? You have association on one hand, and then you have the individuals on the other hand. So hypothetically, I think the language of the release, and we know this in practice, you don't want to enter into a release and then go through the back door and go to the agent, the pure proper agent of the individual, to come back to some type of a double recovery. That's why.
And you have about 3.5 minutes left. Can you address the claim that the court improperly dismissed the gross negligence and breach of fiduciary claims, and what evidence you present or allegations you made to support those claims?
We went in on the third amended complaint and we created specific allegation, even though the Florida rules of superseded say all you have to do is just a short statement. So we went back and tweaked the third amended complaint to conform to the analysis that was issued by the judge in the Jade Wynn in federal court. Granted, it was a denial of a motion for summary judgment, but the claims are identical. The property management contract is identical, and the issues that we have here arguing about those tort claims are exactly the same as in the court. And the court in that case specifically said, first of all, you have a contract, the property, and I apologize, I'm rushing. You have a property management contract that specifically carves out gross negligence, meaning that this whole thing about being a, post-tiara economic loss doctrine or independent tort doctrine goes out the door, because by contract, the parties have acknowledged that you can be sued for gross negligence. Two, as a property management company, let's say, for example, that they had the obligation to create the financial support for the association. Okay, that is a breach of contract. Specifically in the third amended complaint, if you go from paragraphs 32 to 37, we specifically say that they found out that they had relied on improper reserve studies. They had gone way back to 2005 from the developer who had said, this is the prospectus, these are the reserve components. So here comes FSR, plugs numbers. Now they find out their mistake, and instead of telling the unit owners and the association that this is our mistake, they cover it up. That is gross negligence. Right there, the analysis must stop. We must be allowed to go to do discovery and depositions to find out the truth and the evidence. Now, you have also something else where we say they deleted official records of the association. Like, you cannot come and argue that the property management contract requires them to keep the document. Yes, it does. But when you do an intentional tort, that is independent of the contract. Another thing, they went into the vendors of the association and said, hey, the association wants a donation from you for the Christmas party. Okay, good, great. Let's figure it out, through discovery. But for the purposes of this appeal, what they did is they get money from the vendors, and instead of putting it in the account of the association by their own internal rules and the law, they give it to their own employees as bonuses. We have alleged that. So the other stuff that we have is there was a big litigation between the association and the developer. Money, substantial amounts of funds were coming into the association designated to fix the structural integrity of the building. And I know we are post Surfside, and it's not a joke to mention the Surfside, but basically we have a brand new condominium building. We have litigation funds that are coming in. And then you have the property manager that doesn't tell the board or doesn't tell the unit owners, wait a minute, you cannot materially alter the front door of the building just because this board, and that is why we sued the board members in that respect. They use the funds for personal, but the property management itself, FirstService, has a duty, has an extra contractual duty that not only is provided by the contract, but also because of the nature of the relationship. You are the property manager. If you see something wrong, you got to speak out. If you see that you made a mistake, you got to let the unit owners and the association as the principal know. Those things we allege, we have it in the complaint. And again, I know my time is expired. All 15 of it. We rely on the briefs and the cases that we have. Some from this court. There is not one document that specifically says that FSR is the agent of the association. And again, the low threshold was completely ignored. We have specific allegations of tort claims. It has to go to the jury. And one last thing, and I ended up with that because it goes to the release that your honor is very concerned and should be. If there is if the language of the release is susceptible to true interpretation, then now we have a question of intent. And we have to go and get those board members and say, when you said agent, what did you mean? Did FSR come into your mind? That is improper for a motion for summary judgment. And with that, I appreciate, and we want this case to go back to the trial court, and I appreciate your time.
Okay. Thank you, sir. We'll give you a couple minutes to rebut. And with that said, Ms. Kelly, why don't you take, in addition to your 15 minutes, if you want to take 17 minutes, that's good. Totally.
Thank you. Good morning, everyone. I'm here on behalf of FirstService Residential Florida Incorporated, the manager of the association and the appellee here. I'll address first the issues related to the independent court doctrine. So this court, as recently as June, in the UNCJ2 Air versus Whittington case, reaffirmed that the independent tort doctrine requires that a duty be alleged that is not within the contract, that in order to recover tort damages or make a tort claim, you have to allege some duty outside of the contract. Mr. DeVici, in his argument and in the initial brief, has characterized this the order that was entered in the court dismissing the various iterations of the complaint as a procedural issue with respect to specificity. That is not the case. What the court decided was that the association failed to allege a duty that was outside of the contractual breaches that they were alleging. And they were given multiple opportunities. We ended up with the fourth round of the complaint, which was the third amended complaint here, despite being given many opportunities. First, MEI never asserted any claims that had a duty founded outside of the contract itself. In fact, they're just repetitions of the contract and the contract requirements. And to some extent in the third amended complaint and the previous iterations, the association conflates the breaches of the contract with the duties under the contract. They say, well, you did something outside the contract when you breached it. But if you failed to complete a duty required by the contract, that's still a contractual duty. And the brief and Mr. DeVici today are relying heavily on the Jade Wins matter. So I want to take a look at that case briefly and explain why the two arguments that were made there and that Mr. DeVici has adopted on behalf of his client here fail. For one, Judge Mark in that case, it was a bankruptcy case that was filed against my client. I take issue with the fact that these are not identical claims or identical contracts, but they're certainly present here and we should address them. So that was a case where the issue presented to the court was an exculpatory provision or an indemnity provision that the FirstService, the manager argued, prevented the association in that case from moving forward on its case. We never made that argument here. The exculpatory clause was asserted as an affirmative defense, or the indemnity provisions as an affirmative defense, but that was not the issue here.
Do you agree that the federal court in that case found that the statute, the subject of this case, 468.4334, I believe it is, created a private cause of action?
So actually, I'm glad you raised that point. That's one of the things I wanted to talk about. First, Judge Mark in the bankruptcy court never addressed whether or not that statutory provision did or did not create a private right of action, just simply wasn't argued in that case. Here, we've made clear that 4668 never has any private remedies. It can't form the basis for a private right of action against the parties. And moreover, I think it's important to look at the language of that provision. And I'm going to just read from that. The provision says that a community association manager or community association management firm is deemed to act as an agent on behalf of the community association as principal within the scope of authority, within the scope of authority authorized by a written contract or under this chapter. It doesn't say that the scope of duties is strictly under this chapter. First, it references back to the contract, and we have a contract here. It also says, or under this chapter. So that suggests exclusivity. If there were not a contract between the parties, then perhaps the parties could look to the chapter. But it's not even appropriate to be discussed in civil litigation, so regulatory or licensing statute, and doesn't really apply. So the statute suggests the written contract with respect to the scope of authority supersedes the scope of authority set forth in the contract. And another thing that statute does in subsection 2 is it permits the type of indemnity provisions that are present here. And so I would like to go back and look at those. In the Jade Wins case, the court cites to partial language from the contract, right? And the reason the court brings up the contract is it says, similar to what Mr. Dervishi has argued for his client, that the contract complicates the independent tort analysis. I don't think that's the case at all. And we can look at that. On star page 2 of the opinion, the court says that FirstService will not be liable, and FirstService, it's a different name there, shall not be liable to the association, and then there are ellipses, ... for any injury, loss, or damage to person or property unless caused solely by FirstService's own gross negligence or misconduct or arising solely out of a material breach of the contract. So the court suggests that by mentioning gross negligence, that somehow that alters the requirement that a separate duty be pled. Not the case at all. In fact, even in this snippet of the contract that is alleged, it's clear that the contract actually contemplates claims for injury, loss, or damage to person or property damage claims, and personal injury claims that might be brought by the association or someone else that would require indemnity by the association to the manager. So those are tort claims. Those are claims that have duties that arise separate and apart from the contract. And so there's no alteration in the independent tort doctrine. Additionally, in this case, if we want to look specifically at the contracts that are at issue here, and those are found at page 315, which is Exhibit A to the third amended complaint, and at 324 of the record, which is Exhibit C to the complaint, the contract, again, both at paragraph 9, and I'll cite from the 2014 version first, the association hereby expressly agrees and understands that the manager shall not be liable to the association, its members, or to owners, their guests, or invitees for any injury, loss, or damage to person or property unless caused solely by the manager's gross negligence or willful misconduct or arising solely out of a material breach by manager of the contract. So again, the reference to gross negligence applies to negligence cases that could be brought against FirstService, for example.
But didn't you just read the second part of that addresses misconduct? And isn't there an allegation in the complaint that alleges that there was theft or misappropriation of funds? And go ahead.
Yes, so the first thing I think that needs to be made clear is that the association in this case, despite having many opportunities, never brought any intentional tort claims here. They did not bring a claim for fraud or misrepresentation. The only claims that were brought were for negligence, gross negligence, and breach of fiduciary duty, and of course, the breach of contract claim. But this provision is an indemnity provision that says that the, and you can look at it, obviously it's in the record at 315 and 324, that requires the association to indemnify the manager for claims after they've been adjudicated, whether by the association, by third parties, by invitees, and it says that, consistent with the statute, that the manager will not get indemnity in cases of gross negligence or willful misconduct. That's all this is. That doesn't alter in any way the substantive standard in the courts that in order to plead an intentional tort, one must plead a duty separate and apart from the contract. If there are no further questions regarding that, I'd like to move on to the settlement issue. So again, I think it's important not to speak generally, but to look at the actual language of what the claims were and what was released in the release. The brief sets forth, and it's in the record, there's an overlap of allegations between the case that was brought against the individual board members in Miami and the case that was brought, as Mr. Dervishi said, several months later against the manager in Broward County. And the overlap of those allegations is set out in page 391 through 394 of the record. So even in the initial brief, even in argument today, Mr. Dervishi has admitted, and his client has admitted, that the claims are the same. It's the same conduct, and according to the initial brief, the parties were colluding with one another. So they were acting in concert. They were acting, in our opinion, as principal and agent. So with respect to the agency issue, the association is conflating the issue of whether or not a board member of an association can have individual liability for acts that he or she takes while on the board of the association, with the issue of whether the management company is the agent of the association through the board of directors acting as a body. So when you look at those allegations in the Miami complaint, they are, this board made decisions. There are no allegations that these folks acted individually off the reservation, having nothing to do with their duties as board members. They were acting as board members and they were instructing FirstService, and FirstService was working directly with the board, and the allegations mirror one another. The faults that are claimed against the board are the same faults that are claimed against FirstService. So looking at the language of the release, the settlement agreement resolves any and all claims between the parties arising from, related to, or corollary to the Miami litigation, including any and all claims, counterclaims, cross-claims, third-party claims, and all other disputes between these parties that have either been asserted in the Miami litigation, that could have been asserted in the Miami litigation, or may arise from or relate to the subject matter of the Miami litigation. There cannot be any serious dispute that these claims are the same, and that they could have been brought as third-party claims in the Miami action. And the release includes, as you know, as many releases do, all assigns, heirs, successors, predecessors, employees, agents, affiliates. So it's clear from the case law that we've cited that extrinsic claims to the litigation can absolutely be released when there's a broad general release, as there is here. The court in Dryden, which we've cited, specifically warns counsel, be careful when you draft these releases because you could be releasing claims that are extrinsic to the litigation. Certainly here, the association knew that the claims were pending against FirstService, that the claims mirrored the allegations in the Miami litigation, and that they could have been brought as third-party claims. The addition of that third-party claim language absolutely eliminates any potential ambiguity with respect to what was released in the settlement agreement and release that led to summary judgment here. The lower court should absolutely be affirmed, both respect to its dismissal of the independent or the attempted independent tort claims, and with respect to the summary judgment on the release.
Great. Okay. Thank you. Mr. Rich, you want to take a minute or so here and wrap it up?
I will do the same, Judge, and I will rush a little bit again. I apologize. First and foremost, again, not to belabor the point, the release, the language of the release is either unambiguous and you have parties, and if FSR is nowhere near agent of the individual board members, then there is absolutely nothing to release. The cases that have been cited in the answer brief talk specifically about the relationship of the third parties that were intrinsically involved in those particular cases. I take offense that Ms. Kelly says that we could have done a better job. We did the perfect job. We settled the case, no admission of liability. The language is, if it is susceptible, then it needs to go back for intent. And two, FSR, knowing very well that true, the allegations are similar because the wrongful conduct is similar. However, we're missing the point. The point is, you need to look at the scope of the liability. It's one, for example, I'll take the use of the funds from the settlement agreement that they got from the developer. We go to the board members and we say to them, you individual board members did something wrong over here. And not only was it wrong, but you used the money for personal gain. Now, with the same token, I can get the same premise, the same foundation, and go towards FSR and look at FSR's contract, pursuant to the statutes, the agent of the association, and then I look at the scope of the liability. The scope of the liability to the FSR is, one, contractually, that you have to assist the association. You don't have to be the lawyer, but you have the obligation to tell the board in its entirety that you must go to professionals, lawyers, accountants, auditors, and tell them, this is what we have. This is the mistake that we have. We need to correct. So it's different liabilities to different perspectives, to different angles. FSR never came to the Miami-Dade litigation. They could have intervened if they wanted to. We couldn't do that. We couldn't bring the FSR. We would have loved to bring FSR to the Miami-Dade litigation because we would have had everything together, but we couldn't because the contract specifically says venue must be in Broward County. Going to Jade Wins real quick. And Judge Harper, you continue to go to the same issue and the answer is not coming from the opposing counsel. You have an allegation of duty. Page 301 of the record, we, under so many times, we went back, beefed up the complaint, beefed up the allegations. And on paragraph 32, we specifically say, independently of the obligations of the management contract, FSR had a duty to notify the association. And then we go through a myriad of allegations as to what they did wrong. And you pointed out, what about even if you ignore these whole things that they had some type of collusion, we're not interested in the collusion at this point. We're interested as you, the FSR, the agent of the association, to do what you were supposed to do under the contract. You didn't do that, absolutely. Two, you have assumed duties, and that's where the Jade Wins analysis comes in and says, you have a duty that is by the contract, by the statutes, and by the specific nature of the relationship of you being the property manager. One last issue, this whole thing about analyzing section 9 of the property management contract, and Ms. Kelly went into detail regarding the hold armrest. It was never part of the motion for summary judgment. It was never argued, never relied upon by the lower court, because the only thing that the lower court did was, in one sentence, said, I don't want to look at anything. I consider the property management company to be the agent of the individual board members. You cannot have that. You either have an intent or you have an unambiguous document that specifically says, under the statutes, under the governing documents, there is nothing to release. Individual board members in their individual capacity have no rights bigger than the unit owners. You cannot go to the property management, period. The cases are in the briefs, and I apologize for overrunning the time, and I would respectfully ask that the case be going back to the lower court for further determination on the merits. Thank you.
Okay, folks, thank you very much.
I'm sorry to speak again, but Mr. Dervishi raised something for the first time in his rebuttal that wasn't raised below and wasn't raised in the briefs. Just like to take 2 seconds to address it. They did not argue that they were unable to bring the action against my client in the Miami action as a third-party claim because of the venue provision. Of course, the venue provision wouldn't have stopped them from doing that. They could have challenged that if they'd chosen to do that, or they could have brought all of the claims in Fort Lauderdale. Venue doesn't have anything to do with it, and it wasn't raised before the rebuttal. So,
Okay.
thank
All
you.
right, folks, thank you so much. And we will be in recess until 10:45.